How did Roman law define actio, legal action? Imagine living in ancient Rome and needing to settle a dispute. How would you go about making your case in front of a judge? That's where the idea of actio comes in. Roman law used the term actio to describe the legal right of someone to bring a lawsuit. It was the main way people enforced their rights and sought justice in court. The word actio comes from the Latin verb agere, which means to act or to bring a case forward. Think of it as the formal process that allowed a person to ask the law for help when they believed they had been wronged. At its core, an actio was the formal procedure a plaintiff used to get a legal remedy for a wrong or to make a claim. The Romans saw actio as the tool to make sure justice was done. They divided actio into different types based on what was being claimed and who was involved. One major division was between actio in rem and actio in personam. An actio in rem was a claim made against a thing, like land or property. It was used to assert ownership or rights over a specific object. For example, if someone claimed they owned a piece of land, they could use an actio in rem to recover it from anyone who was interfering with their rights. The most famous example of this was the rei vindicatio, which was used to reclaim property that belonged to the person bringing the action. On the other hand, an actio in personam was a claim made against a specific person. This type of action was used when someone owed a duty, like paying a debt or delivering goods. It was about forcing the other person to do something they were legally obliged to do. Later, Roman law called these personal actions condictio. These actions could be used in cases like unpaid loans or broken contracts. Roman law also classified actions based on where they came from. Civil actions, called actions civiles, were based on the traditional Roman law, the ius civili, and were only available to Roman citizens. Praetorian or honorary actions, called actions honorarii, were created by the praetors, the magistrates who could adapt the law to new situations. These actions often provided remedies where the civil law was silent or too strict. Roman legal procedures evolved over time. In early times, lawsuits followed the legis action system, which was very formal and involved specific verbal formulas. Later, the formulary system made things more flexible. The praetor would issue a formula that set out the issues for the judge. During the empire, the cognitio extra ordinem system allowed officials to control the process more directly, making it easier to handle complex cases. People used actio for many everyday disputes. If someone's property was stolen, they could bring a rei vindicatio to recover it. If a debtor refused to pay, the creditor could use a condictio to demand payment. The praetor could also create new types of actions, like actio in factum, which focused on the facts of a case rather than strict legal categories. Roman law used specialized terms for different kinds of actions. For example, predatory actions aimed to recover the thing itself, while possessory actions only dealt with the right to possess. Some actions were direct, following the exact words of the law, while others, called util actions, were adapted to new situations by analogy. Prejudicial actions helped establish a person's legal status, which could influence other claims. The way Roman law defined actio shows how practical and flexible it was. It was designed to resolve disputes efficiently and fairly. The law could adapt to new circumstances, especially through the work of the praetor, who could create new remedies. This ability to change and grow helped Roman law stay relevant for centuries. In the end, actio in Roman law was the main way people asserted their legal rights. It distinguished between claims against things and claims against persons. Its procedures were clear but adaptable, making it a strong foundation for justice in ancient Rome.